We don't always get Roger in Utah.
We are live today. It's the Senate Government Operations Committee on Tuesday, April 2nd. I cannot believe it. And we are packed. We have a packed afternoon. And we are going to come back to something we spent a lot of time on last year, S-17, the sheriff oversight bill. And you will recall that we requested a report in that bill. And Annie Noonan is here from the Department of States Attorneys and Sheriffs and States Attorneys. States Attorneys and Sheriffs, DSAS. And is going to walk us through the report and the recommendations. And so I'm gonna, you know us, both of you, and Roger Marcoux is here as well. Sheriff Marcoux, thank you for joining us.
Thank you.
So we're just gonna turn it over to you to walk us through the report, and then we probably will have questions. And if you wanna just refresh our memory on the layout, that'd be great.
Sure. For the record, Annie Noonan, Department of States Attorneys and Sheriffs. I work at our central office. My job title is Labor Relations and Operations Director. I've been with the department about 7 years.
Roger Marcoux, Moyle County Sheriff, and I'm the first vice chair of the Sheriff's Association.
And thank you for inviting us to talk about this. And Roger and I were meeting earlier today. And so I thought for efficiency, and I know you on a tight schedule, we'll do it together so that we can answer questions from the sheriff's perspective. But to refresh everybody, last year there was a lot of work around S-17 that resulted in Act 30. And basically the report that you have in front of you is probably way more than you need. But for someone reading this who would say, well, what are the duties of a sheriff? A big part of the middle section of this is all the things that a sheriff is asked to do. I think, that's sort of at your leisure, you might want to peruse through that. Let me go through what was asked for in Act 30 and give you an update as to where we're at. So the first thing is Act 30 imposed additional oversight on the sheriff. By side judges, by our department and the state auditor when they're dispersing or transferring any department assets in an aggregate of 10,000 or more during a transition between sheriffs. So that can happen when a sheriff leaves office or during a term or when the sheriff is not elected or decides not to run again. So that is an oversight because there was some question about some disbursement of equipment and money that may not have necessarily left the incoming sheriff in this grave situation or that department in this grave situation as people were.
Orange County.
Yes.
We're talking about Orange County.
Yes.
In a word.
Not to name names,
That's
but.
There's not another one that's happening.
In all fairness, egregiously in Orange County, but in other counties as well, we've had this issue.
Yes.
Maybe not as dramatic.
Okay.
The other is the auditor, the sheriff must notify the state auditor and the department if they establish or participate in a nonprofit organization that has a mission to supplement that of the sheriff. And some of that came about when Sheriff Newton, prior Sheriff Newton out of Addison County, sent out a fundraising letter to everybody in Addison County, setting up sort of what looked like a program that was replicated by some of the nonprofits and perhaps even the sheriff's department. So there was some question as to why was that. So we're trying to make sure the sheriffs understand, stay in your lane. And if you're going out of your lane, let's look to make sure that there's no conflict, that you're not stepping on or duplicating work that's being done by other people, or perhaps a conflict of interest. The third piece of this was that if a sheriff, it says if a conflict or appearance of conflict arises, the sheriff has to disclose that to the executive committee. And then recuse themselves from the matter until it's reviewed. The executive committee is actually a term we use because the statute uses that term. But in essence, the Sheriff's Association and the executive committee more or less replicate themselves. So they're elected from among the sheriffs. Sheriff Anderson is currently the chair of the Sheriff's Executive Committee and the association. Sheriff Marcoux being the vice chair. And then you have Sheriff Fox from Rutland and Sheriff Harlow from Orleans and Sheriff Gamlin from Chittenden. No?
Yeah, I think you got it.
Yeah. So it's basically a smaller group of the 14 and they get together and they even do things like, just for information. So if a vacancy were to arise, there would be a conversation about, does the vacancy get filled there or does it get filled somewhere else?
Okay.
And that's a matter of, not only staffing resources, but we're trying to be very careful that the transport deputies, and we don't have a role over any of the non-state positions, but there are 24 state transport positions. So, for example, we have not given a transport position to Orange County. Part of the reason for that was in a period of almost 18 to 20 months, we only saw 3 transports done. When we went back and looked at records, one. And when the incoming sheriff, at that time Sheriff Contois, came to me and said, I need to fill that position. I said, you only did 3 transports in 18 months. What do you need a position for? And he said, I only need them for my private contracts. And he said, that isn't the way it works.
Yeah.
So for that purpose, we've been having other offices, other departments are backing up to Orange County. They don't have a lot of transports. When they do, they've been assisted by most of the other counties. Now, if we were to see a big uptick in a county, we would sit down and talk about it again. We're right now considering what happens in Franklin County, because Franklin County does have a correctional facility there, and there are a lot of transports. Right now, it's being handled out of Chittenden. There is conversation about whether or not we should be supporting Franklin County again. I think to some extent, we were hoping to see Franklin County moving in the right direction. So that's not been decided, but those are the kinds of decisions that the executive committee and the department make together. So there is oversight in that regard. There's also the financial disclosure that has to be done by the sheriffs, and all the sheriffs, I believe. I was notified by the state that everybody did comply with this,
Oh, great.
which was helpful. Developing a model compensation and benefit policy for the sheriffs. We're looking at that, and we've been working, I think, towards that. There's a couple of things on the table with that. Until such time as that is done, I think that's going to be of great interest to all the sheriffs and to obviously the department. But what we're looking at would be, there's lots of comparables in state government and in municipal government. One of the things that's really important and that we see as a major equity issue is retirement. And I do want to say, if I can, a plug for H588, which is the retirement bill that would let the sheriffs, again, I want to say non-state employees, but the sheriffs and the non-state deputies be able to go into Group G at no cost to the state. Because as you know, Group G has to meet itself for the cost. And I think that would be really put us in a better equity line with others. Because what happens now is a lot of the sheriffs, they bring people in, they send them to the academy, and then they're with the sheriff department for a short period of time, and then they leave because they can get a 20-year retirement with somebody else. And I know we've had select board people from Lamoille County. I remember Susan Bartlett came in and testified at one point and said, we're just basically training people up for the munis, and it's really hurting us. So I do want to put a plug in for support of that. And I know there's an amendment on that for the reduction. If somebody has no law enforcement certification, it's coming through at 30%. And I do want to say that seems, this report actually talks about someone who has no certification should, there's the full pay, there's the 10% reduction if you are a level 2. And then I raised the question, I think when I first testified here, what do you do about somebody who has no certification? What should be, the legislature at some point decided that if you weren't able to do the full job, what should your reduction be? And I think that, so they did at one point set that precedent of full 10, minus something should be the next logical step. So we would say that what we've seen come across at perhaps the 30% maybe makes some sense. And I think maybe would be sustain any challenge, I think.
It's questionable whether it's constitutional. I've already discussed it with legal counsel,
Yeah.
so, yeah. Because it's basically setting qualifications for office, which we don't have the legislative authority to do unless we amend the Constitution.
Unless we do what we hope to do.
Yes,
Yeah.
so that was, but I don't want to get into those weeds now,
Absolutely.
but I am interested to hear in the report how you came to that 30% too.
Yeah. So then we also did, Brett, do you want to say any more about the 5% contracting. Position.
So this isn't done yet, the policy hasn't been completed
We
yet.
have
It's sort of in the
one, we
works.
have one or two that are kind of vying for a blend
Okay,
that haven't been done yet.
got it, okay.
When are you hoping to have it finished?
Maybe after the legislative session. No. Would say that with no disrespect, it's just we're right now.
You're busy right now.
Yeah.
Yeah. Did you wanna add something, Roger?
I don't think I have anything to add. It's just that currently the way that the situation is that sheriffs can't take the full 5%, but after the session last year, sheriffs with beyond 2 years of experience can take up to 50% of their base. So that brings in the top person, which is probably me at around 147 if you combine my base with 5%. The rest of the 5% can go or should go into the department.
Mhm,
So and that's where we're at right now.
mhm.
And I'm sorry, the level twos are the sheriffs with less than 2 years experience are 10% of their base.
Mhm. Mhm. Okay.
Oh.
Maybe it's hard for that one.
So it's helpful. We had a chart last year, we can probably dig it out, yeah.
So the number 6 is to create the position of Director of Sheriff Operations for centralized support with lots of other policy development, making it as compliant with all the provisions of Act 30. I did bring a copy of the job description, and I can send it to Olivia for posting. But
That was great.
we had two very viable candidates that we had been trying to convince to work on, take this. One was close and then basically said it looked like a little bit too much work for the point that this person's like, where they're at, where they don't want to take on that kind of level of work. And then another person who we're still in conversation with, but we're going to post it again.
Okay.
So it's just an interesting job description if you see, because what we did is we mirrored in the job description much of the work that has to be done under Act 30. Because there is a lot of work for policy development, monitoring and compliance that you know that we're trying to do. And honestly, at this point, the compliance oversight is really fallen to a large extent to myself, Roger, and Sheriff Anderson.
Yeah.
Reminding people of things and just, you know, staying on top. We have monthly sheriff meetings and usually I pop in to kind of remind them of things and say, don't forget to do this and don't
Yeah.
forget to do that. But I think we've got a very good group of people who understand how important this is. We talk about it a lot. I
Good.
think that's helpful.
So but just to be clear, the position has not been hired yet, you're still trying, you
Right.
have one person who's a maybe and then you're reposting,
Yes,
okay?
yeah.
Cause I've gotten asked this question multiple times, so that was one thing I was like, we'll ask Annie
Yeah,
when she's
yeah.
here.
It's really interesting though. If you get a minute, and I know you're busy, but it would be interesting. It's an interesting read. If you know anybody you think would fill the bill, I don't know, maybe I could coax.
Sure. And her pay.
I think you would be really good for
That's
this.
what
You would be great.
Bob is a natural.
Senator Clarkson has a question.
Yes.
So we have the equivalent for the state's attorneys, right? Is that what Tim is?
Tim is the director of, Tim is the SAS Legislative and Policy.
So he's not the director for that. So who's the equivalent for the?
The
state's
Director of
attorney?
Operations, that would be me.
Yeah, okay, so
Similar.
you're right now doing both.
I do labor relations and operations, right?
That's what I thought, but for both.
Yes, right now I'm kind of overseeing some, but in terms of the sheriff operation piece, you know, as you know, that they run it's that public-private ventureship, that weird combination that was set up by statute. So I don't oversee what the sheriffs are doing per se right now in their private operation. They, you know, whether they have a contract with Pike or with, you know, UVM Medical, that's all sort of on their business, as long as they're complying with, you know, keeping their records. I do help the state auditor when Doug will call me and say, I need more books from so-and-so or more information. So I just, right now, the sheriffs are doing a good job of managing like the transport program, and we've got them working more closely
And coordinated.
and coordinating better, you know, although I want to say, I will tell you this, there's been a real challenge. I had this conversation with Judge Zone. Where corrections used to do, I don't need to tell you how understaffed corrections.
Yes.
I really don't. So, so they don't want anybody leaving the facility, right? Because they've got to staff the units. The problem is and they have a transport team, but they're very busy and they're moving people around a lot. But years ago, there were things that they would bring people from the facility to court for. And so now it's sort of like, we don't have capacity, so you've got to do it. And you shove that work on us. And I had this conversation with Judge Norman. And I said, so here's the deal. I said, think about it this way. Our universe is forever and ever has been this big. These are the tasks we do within that universe and the number of staff and the money that we have. And now, because everybody else is saying, well, we can't do it, and throwing it on us, we don't have more staff to do that work. We just don't have the capacity. So there are going to be things that we say, no. And, I looked at it from the perspective of all of the infrastructure that got set up, massive millions of dollars of infrastructure for IT that got set up to allow remote hearings. And, so some of the things that could, and I know that presents its own problems in the facilities, but, we shouldn't mothball that equipment because that really could take some of the pressure off of the transport. So I did say to Judge Sone, here's the deal. If you commit us to a TPR hearing, termination of parental rights hearing, and you want us to move somebody from the facility for that, and then a transport comes in for something very serious and there's nobody there, I'm gonna tell you, I don't know what we're going to do. You have to help us prioritize. It has always been the criminal hearings and the juvenile proceedings, not the TPRs, not divorce cases. We don't have the capacity to do that unless you want to add to the positions. And we, it's Roger, I think Chef Marcoux were talking in the hallway. How long does it take to get somebody from point X to level 3 certified? And you're talking 18 months if you can find them. Right. So we're just in a little bit of a bind right now. I'm not asking for new positions. I'm just saying to you, we've had to sometimes say, what prioritize? Where do you want us?
So suggesting that, some of the, instead of transporting somebody from a correctional facility, having them come in by WebEx. Yeah, okay, that makes sense.
They're doing.
It's
Not
up
as
to,
much,
it's up
yeah.
to some extent, it's up to the judges. And I've asked Judge Sone, and he said, yeah, we're trying to encourage that when it should be, when it's logical. But, in some ways, they can't always accomplish that.
Yeah, go ahead, Simon.
So aligning. Roger.
Roger Marcoux, Ann mentioned TPRs as termination of parental rights
Yeah.
for anybody that doesn't
Right.
know, which is a very,
Halfway. Exactly.
very busy,
Yeah.
So
transfer.
if we're beginning to coordinate better on transport, are all the sheriffs coordinating on contracts too? So Pike, that's like a statewide contract. Do you do statewide contracts that all 14 of you buy and, do together?
What we've done is we not too long ago, we started doing that with all of the state contracts. So that instead of having a contract with DCF and then mental health and everything, we just had one contract with one contract rate and the sheriff signed up on that. The Pike, for example, some of those folks, it's dependent on Chittenden County. It costs them a lot more to hire a deputy than it might in Orange County. So those contracts are not coordinated in the way that you.
Well, that brings up an even bigger question, which is you don't coordinate on pay scale? Aren't you all paying similar?
No. Because it all depends on how successful a business person the sheriff is to be able to pay his or her deputies.
And that, when we asked for the
Right. I thought
the
that was-
compensation and benefits
Yeah.
model
Yeah.
policy, will that be addressed in that policy, do you think?
I think some guidelines will be, so, Roger and I were talking even earlier about, are there levels of skill set? So do you create like, a deputy
Yeah.
1, 2, 3, you bring people in at different levels, right?
Yeah.
Based on their experience, that maybe makes some sense to be doing it that way, and it gives some of the newer sheriffs maybe some understanding of, what's the market?
Well, and it makes it less arbitrary, and I mean, we had to do that in this building because every little office was its own little fiefdom and everybody was setting their own pay scale benefits.
But But the difference is that that money is coming from a centralized location. What I'm seeing as a failure point for sheriffs is that, sheriffs are hiring people full-time, for example. They're paying them benefits, and they're trying to compete with union shops, with the municipalities and what have you. And then what happens is that, right, we've got these people full-time because we need them in case we have contracts from the towns especially. Then what's happening is that they're not working a solid 40-hour week for the town receiving compensation. And then that leaves it to the sheriff's department, and they still gotta pay this individual for those 5 hours or 10 hours and it's getting sheriff's departments in trouble.
Yeah, they're not matching up the work with the personnel.
That's right. So,
That's a tough.
so in essence, that's where it's very difficult and it depends on the region as to what you can do. Because most of these folks that I see doing that should really be trying to find people that can work part-time. So that when they're working part-time, they're being paid, but when you don't have any work, then they're not working. And those benefits are nearly 50% now.
But there is work. There's lots of work that needs to be done. It's just not evenly distributed.
Well, yes, well, for example, in this building, the Capitol Police need 2 people this week. So, all right, so it's just trying to find who out there has got somebody that they can put. And then when the Capitol Police are done with that person, where then can you put that person to
Right.
help?
Cause you're right, we have a lot of sheriff.
Yes, so a discussion for another time, is
Yeah,
really the marshals, the way the
Yeah.
US Marshals do it.
But I think you're right, Sandra, if you want to bring somebody on, you've got to have enough income coming in from whether it's a combination of contracts or one contract even, to make sure you're able to pay the person. And one of the things we get asked a lot, from different state agencies, I was asked by, Office of Child Support, could we get contract with our folk, the transport deputies, to deliver child support services, to go find people. We were like, well, we don't have the capacity because there's only 24 of us and we're running around the state with transports, but like talk to your local sheriff. See if or talk to the sheriff executive committee, maybe they'll come up with a reasonable contract that, how many hours a week does that look? What does that look like? I always say, like, how many hours would you need somebody? Let's talk to the sheriffs and bring it to the executive committee. So I invite people randomly to their executive committee meetings. I'm always telling them when they got a new guest they don't know about, because they need help. A lot of the state offices, I even got approached by the Department of Labor for stuff with VOSHA.
Yeah.
The VOSHA staff that go out and they sometimes they're met, with very angry, if they're gonna fine or close a business down, it's pretty confrontational, and they're not law enforcement officers. So, so we've been asked for very odd but important things. And I always try to hook them back to the executive committee because they might be able to figure out, well, we can do that with a contract.
Yeah.
Interesting.
Okay, so
Okay, carry on.
number 7 was that each sheriff is to maintain a record of their work schedule, including if they're working outside of their district for more than 3 days. We advise people to use their Outlook calendars daily and to keep that available so that if there's ever a query, that they would be able to produce that. Some people are really, really good, like almost like a lawyer's, like a billable hour thing, and others just say, where they are. If they're on vacation, they put annual leave or wherever they're doing. So I think that's important. Am I able to tell you that that I can monitor this? No, but they know that is a requirement. And I know at one point I did remind one of the sheriffs who I had heard was not, and I reminded that sheriff that, if they were working from outside of the state of Vermont, they needed to be putting that on the calendar so that was available for anybody to know.
Yes, I wouldn't be surprised if the press asks at some point
Yeah.
and they be able to turn it over. Yeah.
So this piece about number 8 is the sheriffs have been working with Judge Sone and Court Administrator Perry Croissant's court security, and that was a separate presentation I know you've heard about.
Yes, and I was actually gonna ask you if you know what the status of that is. I know Terry was going to work on trying to get this in the budget. Do you know if it's in the House budget?
I think
the single statewide contract,
Well, part of this was to try to get more people to.
right?
I might wonder if Senator Norris, did this come up in the
The
Senate
House has
Judiciary?
already passed. It did come up. We made simply, we had a wish list for recommendation of position like to see filled. It's my understanding that all of the judicial positions were filled in the House. They're passed out.
Oh, so this is in Martin's bill. This is in the House Judiciary bill.
I think it's in the House
The
budget.
House budget.
Yeah, I don't know how
All the
many
positions
positions, did they give them all of them? They asked for a lot.
I think like 70 or.
Oh, really?
Oh, yeah.
Holy cow.
$7 million.
You got the 21 deputy sheriffs, you got 15
Court officer.
court officers, you got 10 deputy state's attorneys. And then there's the Defender General's office along with, they all came in, it was an enormous package.
That was sort of the whole pre-project.
The whole thing.
Okay, and that would, these weren't included in that big package. And you think it's in the House budget, Senator Norris?
I believe that it is.
Okay,
We
we
did a
might,
bill and in the budget. It's in Martin's bill that came out of House Judiciary and I think in the budget.
Martin spoke, on the floor when it came to the big budgets in support of the
okay,
budget they came.
maybe we can get a little just briefing from Ledge Council and JFO about what's included, so we have an understanding of it. That, I mean, this came out of S17 and the work in this committee room, to try to get some kind of resolution on this. Yeah, go
Just to
ahead.
be clear, Senator Norris mentioned 21 deputies, so those aren't new positions for us. So that's just what we're gonna be required to provide.
I thought, wasn't the recommendation that they be state,
Classified.
similar to the,
State qualified.
yeah.
I thought
yeah.
it
Well, the
was.
But
judicial,
they wouldn't be
That's fine.
But not
people,
for
they
us.
would just be.
No,
yeah,
judiciary position.
They would be judiciary positions, but they would be sheriff deputies that were working on court security.
there was a differentiation. The proposal has the judiciary working with the sheriffs for a contract to provide level 3 court certified. And then they were going to hire some additional court officers who would not have to be certified and could do administrative tasks also.
Is that where they ended up with that? My understanding from Terry was that they were trying to get them to be state,
Yeah.
not through contracts, but state employees.
That was my understanding.
We took
Go ahead.
testimony from the sheriffs that stated, I got a little experience in this, that it would be much easier to fill those positions if in fact there were state classified positions that came with benefits.
Yeah,
Also, the BSA was supported.
that's why, that's my understanding is that that's what they requested. So maybe that didn't come through the House, because it's obviously, well, maybe not obviously, it's probably more expensive.
We'll find out.
But we'll get the, can you just note that, Olivia, if you want some update on
You could
that?
reconcile.
Yeah, just to figure out where that's at, okay.
Okay.
Carry
So
on.
I'm gonna have you turn to page 4. There's a lot of policies that sheriffs have to put together. The executive committee, for the most part, have agreed to, almost all of them, I think, have agreed to serve as the policy committee. Many of the, Sheriff Marcoux provided, basically all of the policies to each of the sheriff's offices. At which point they should start reviewing. And then the policy, the ad hoc policy committee will go through to say, this is what we recommend, but also asking people, some of these are mandatory, so a lot of them are mandatory by the Criminal Justice Council, some of them are mandatory, federal policies and state policies. But, I think that what the most important thing, and Roger and I were talking about this earlier, is you can send out all sorts of stuff on policies, but for newer people who don't necessarily understand all of this, training is most important.
Yeah,
Oh, yeah.
You can basically, you basically put out a binder of policies, but unless they are actually understand what the implications are and how to implement them, really doesn't mean much, when you need policies.
It's policies, has been a huge problem with sheriffs.
yeah,
And Annie mentioned some of the newer sheriffs, some of the older sheriffs too. You've got policies, you train people to the policies, then you've got to train the sheriffs as to what happens when policies are violated. Then that brings into a proper internal affairs component, and so much of this relies on, Annie finding the correct person as the sheriff's, director. Because this is gonna kind of be like herding all the cats together to get them trained.
Yeah.
I see, so.
So this list on page 5, this is phase 1 of the policy, and then it goes on to phase 2 of the policies that you hope to have in sort of a policy manual.
Right.
And do a lot of these policy already exist? And it's,
This came from my policies.
okay,
Yeah.
It's a suggestion,
okay,
and it certainly is better than, I'll bet you there's some departments with no policy.
Yeah.
Except for
Yeah,
in-
I'm sure there are.
They can modify these to make it unique to their agencies, but it's a list of what I've accrued over 24 years.
And have you started to put this together yet? Or where is it? Where's the policy making happen? Where is it at?
Many of the sheriff's departments have requested my policies and we've sent them electronic versions, but we haven't formally. There's the mandatory policies that they're forced to do, in page 1, but we need that corrected.
You know, from what, and I've let the sheriffs know this, and from all of the stuff that they do with law enforcement, I mean, I can't, if I was in reading, intent to be ridiculous, I'd stop my dad. But I said to them, it's like, how hiring and promotion and job descriptions and all the stuff that's labor relations, which is basically that whole section at the beginning of the top, on page 6, which we have policies on in our department, which I think that they basically will mirror. And I really feel good that they've gotten to a point where they are understanding to pick up the phone and call either me, Roger, Mark, someone with most of their personnel issues, not 100%, but most of the time. So we're able to move in quickly, tell them you've got to do the internal under Act 56, or if you're going to, that really needs to be posted. We're really pushing for them to, do things properly, posting jobs, having job descriptions. It's all really important. I think that they're doing a lot more on that. I think they're doing much better.
Satterwhite?
Thank you, Madam Chair, and what a solid list of topics. You've got quite the binder. I just had 2 questions. There's some words in here, I don't know the definition of what that is, so I'll look that up later. But yeah, I don't know what Garrity or Loudermill would possibly be referencing. I've got no concept of this. But I did just want to make 2 points, which is I like seeing that you have social media on here. I'm assuming just based on where it is in your list that that's related to what you would expect personnel standards to be on social media. I also think it would be very valuable for you to consider, while it has certainly not happened here to my understanding, but in other places, I've seen some disturbing content that sheriff's departments have put out, not in Vermont, this is not a comment on Vermont in any way, shape, or form, but it sometimes pops up in the news. And I think it would be great if you also had something around what the department might be choosing to put on social media compared to what a regular business or
Personal.
yeah, where those lines might blur. And I think that would be helpful because there are situations that, I've seen in the news that seem like if someone maybe had just had a little bit of a heads up, they might not have done something. So that's just one point. And then I didn't see anything on here, and I know you have it in your other training, but I don't see a policy around racial discrimination or bias. Maybe I didn't see it in all the bullet points.
Phase 1.
That's
Fair
okay.
and partial.
Oh, the first one. There we go.
Yeah.
Great.
But to the point of the social media, we do training in our state's attorney training in June. And we've brought people in that have talked about the whole issue of social media. And the standard you should say is if you don't want to see it on the front page of the Free Press, you probably shouldn't
Yeah.
put it on your
Yeah.
Facebook, or perhaps even in the role that you have as a public employee, you should be maybe should refrain from a lot of
Yeah.
use of social media.
But it can,
Unless
it's
it's positive.
but it can also be useful. Like I've
It's
seen it used really well by our sheriff's department in particular, where he'll post things that are like, oh, I'm like, oh, that's helpful information. We're looking for XYZ, kind of bulletin stuff. And I know municipalities have kind of struggled with the balance of like, what do we put on that is helpful information because this is where people get information versus what is like not, it can be flashy, it can be funny to make a point and get people's attention, but. So I appreciate that you have that listed there.
Yeah, just
Yeah, go ahead.
tag on the social media, so I would think for sheriffs, there's both personal, not policy,
Yes.
personal social media versus the department's social media, so it's,
That's, yeah,
I think those are two key things. And then just on these, as we are about to have the municipal ethics bill, you have ethics and code of conduct and ethics and conflicts of interest. You have two pieces of sort of, I think, the same pie. Are they both ethics? And who is the ethics board that? Are you, it's your department?
No, we had, we follow the
It's
state
criminal
ethics.
counsel. It's just is it the
Well, the ethics board, in Act 17, we made it so the sheriffs fall under the ethics board. So we are commission, so.
There's a,
I'm sorry.
there's a fail safe too, because you've got whatever we're gonna create here,
Right,
plus Act 56. If someone pushes the line ethically to gross criminal conduct, then they're investigated by Act 56 by the council.
oh, by the
Yeah.
council, right, no, I know that, but I'd forgotten that we had included them.
Yeah.
Directly.
And we started it in
Ethics
here and then the house.
yeah,
Did that a little
thank
bit.
you for this recap.
Yeah, yeah.
It's like, I was like, what actually ended up being in that?
So with these long lists, some of them are required by law and some of them are required by the Vermont Criminal Justice Council. It seems, and I can't remember sort of where the cutoff is, and I'm wondering if there are. I mean, this seems like a really good list, but if we should be requiring other policies by law, or having the Criminal Justice Council do that.
I think once we get through looking at all of this and I want to say that the council staff have been really helpful
Good.
in reviewing this, and we've spent a lot of time with them on this report. Took every suggestion, I think, but one that they put forward. They really did a good job of putting serious review on this. So I think when we get all through, if there are things that are missing, sometimes you don't know what's missing until you need it.
Exactly.
That's the state.
Yeah, that is.
Yeah.
I just mentioned that, in my experience, or if you've got the state, these folks that are looking at this, we also have our labor attorneys that cover us and our insurance companies.
Yeah.
Yeah.
Looking at this, and some of these have come from experiences that I've learned the hard way.
Right.
It's okay.
Well, it seems to me that you have a really good policy book because you've been doing it for so long. And I heard you say not everybody has these policies in place. And so what can we do to make sure that everybody has the
Right.
policies in place? And that's.
I think that this S17 is helping drive that.
Yes.
Okay.
It's our hope.
Senator Vygotsky, did you have a question?
I did have a question. I'm just wondering, I'm sort of scanning through these really quickly. One of the things I don't see listed here is a custodial interrogation policy. What is the sheriff's department's, or is that included somewhere else?
That might be just a determinant
I'm
if we
sure
all
it's-
get through this session.
It might be under a different title.
That's what I was wondering, if it was maybe included in criminal investigations and major crimes.
Yeah, it's definitely good, because, one of the things I know instinctively is that if you're gonna do an investigation, an interrogation or what have you, it's gotta be recorded. So whether it be the body camera or a room set up with that, and I may have to get back to you.
Oh,
Senator,
that's fine,
on that.
thank you.
I'm sure it's in here somewhere.
Senator Clarkson.
Okay, Roger. wanna know what a stinger spike.
I saw that one too.
I know, I think I have a
It's
notion
the
of
thing,
everything else, but
right?
a
So these
stinger
things
spike.
look like an accordion, they have spikes.
Oh, it's a
that-
real thing, it's not.
Yeah, you're trying to stop a car from a high-speed chase. And you're trained to, and this thing unfolds across the roadway, car runs over it, and it slowly deflates their tires.
And that's what happened on 91 with
Yeah,
that,
you guys
that's where the
chased.
death of
Mike.
the, yeah,
Trooper Mike Johnson got killed
Oh.
flying one of those.
yeah,
Oh.
that's. God, that's what I thought.
Wow.
Oh,
But they're very useful when they work well.
Yes, but it's very high liability and very dangerous for the police officer. They're designed not to blow the tire right out, so they're less dangerous for the person you're using it on, but it's very dangerous for.
For the person
who would
deploying.
have freaking known?
Wow, okay.
Yeah, no, I.
Well, that's good to, you should have a policy on it.
All right, well, I think that we'll definitely want to hear more as the policy work continues about, you know, how it's going and what changes might be necessary.
So we have some upcoming training. The sheriffs are getting together in May as they usually do for their annual training. The sheriffs also are and have been over the past few years invited to the, what we call the state attorney staff training in June. And some of those are important plenary discussions with, whether it's with the prosecutors or with advocates. So I think that's been some of the sheriffs have been able to come to that. So there are some of those, the training in May will be again a review of S-17, just to remind people that some work happening there. But similarly, I feel like the sheriffs, the good news is that last year, we were able to get approval from finance and management to keep a little bit of extra money for training for the sheriffs. For the carry forward. I know that will probably be a difficult conversation this year, carry forwards. But we really do, that's, Roger has consistently said training is really
Yeah.
important.
Good.
Senator Yoski?
Yeah, no, I appreciate that. The other thing, and again, it may be included somewhere else that seems to me, to be a really important thing is around de-escalation. Is that a part of your regular annual training as well?
Yes, we usually. Say one, we usually have a mental health professional come in because we work with them so much. In de-escalation, we could use that skill much more than we use anything on her belt.
As it should be. Thank you.
And we always incorporate it into the June training.
Okay, so it is a yearly.
And our, it's always asked for by our administrative and victim advocate staff. Because often people that first come in are upset and they're the first line of conversation.
Yeah.
So
I love the de-escalation training.
For legislators.
Yep.
Family, I mean, family needs the same thing.
Yeah.
All of us need to
Yeah.
negotiation policies.
So I'll probably go
Very
through, which is the current salary provisions. So as you know, the sheriff's salary is set by statute every 2 years with the elected officials. And this is where we came up to the recommendation where we said, with regard to statutory provision, you see the 10% reduction for someone who's level 2, and it was the next paragraph we said, the statute doesn't have anything with regard to the other piece of someone who doesn't have any certification. And here's where we have said we recommend a reduction in groups.
Yeah, and what was behind that 30%? Just, we are gonna take a look at that language in the bill, so, we'll have you back maybe to testify, but just a preview.
Well, we were, I was listening to a lot of it. We were talking when we were working with the sheriffs on this. We were asking them, about the mix of their job being administrative and law enforcement. So one of the things we were trying to do was to come up with something, is if you're not certified at all, there's, the law enforcement, doing those law enforcement tasks really don't fall to you, but you may be able to sign and do that. There's many aspects of that. But what we didn't want to do was get into a situation where it was so low that the cut of the percentage was so low that it became almost a constructive discharge. So I always think that put my labor hat on and spent 30 years at the labor board, up there in front of the board. constructive discharge? What would, I think that, what would pass the reasonable person test for this? And I thought, we were talking about it, so 30% seems to be enough to say you're not able to do the full job, but, but you're still, you don't have to be, by statute, yes, you don't have to even be a certified law enforcement officer to be the sheriff, but you're not doing the same job that Roger's doing or that Mark is doing if you're not certified.
Right,
So, or that Sheriff Forrest was doing.
yeah,
So we thought that just seemed like it was enough, it was a bit of a reduction without creating a constructive.
Well, like 10% per level.
right. And we will take a look at this. I mean, in talking to attorneys about it, there's a difference of opinion as to whether or not this would be problematic in terms of the constitutional.
I just think
provisions.
about the fact that one legislature years ago came up with a 10% reduction and it didn't get challenged.
It hasn't been challenged yet, so I mean, it may be worth doing this just to see if it'll be challenged, and then we'll have the answer to the question. But I think I would like to understand a little bit more, and Annie, maybe you and I can sit down and sort of go through the numbers together to see if we can come up with some sort of mathematical reason that 30% makes sense. Maybe it's just like a time study of like what percentage of the job is done. Go ahead, Roger.
One other thing to consider while you're having this discussion is if you have a person with no certification, like an attorney or somebody, so tremendous other qualifications that wants to run for office, should they be treated the same in this way as someone who loses their certification because of?
That's also a very good point.
So it's something I didn't think.
That's an excellent point. And again, I think this gets us into that sort of murky world of, are we creating qualifications, which we are only allowed to do for probate judges, we're not allowed to do for sheriffs. So that's what we were trying to do with that constitutional amendment, but carry on.
Okay.
We still have a few more pages to get through.
So one of the things that, when we get to the point of really looking at compensation, the good news is we have lots of other jobs in state government and municipal government, federal government, that we can actually look at for comparability. And that conversation I had with folks DHR, that there are lots of comparability. So I think when we get to the point of creating the model compensation and benefit policy, we do have that. We also have the whole question of what's the market factor? Do you have to pay more in Chittenden County? Do you have to pay more in Windsor County? So and I think we can rely to a large extent on the Economic and Labor Market Information Division of the Department of Labor. And I'll give a plug to who I think is the best economist in the state, which is Matt Barowitz from the Department of Labor.
Did you hire Matt?
Matt was there when I got there, but I will tell you this, I do take bragging rights on this. At one point, Boston University was trying to steal him from us, and I was able to go to Jeff Spalding, who was Secretary of Administration, and said, we cannot let him go. We have to figure out how to keep him here. So we were able to basically just, he's the best.
He is so
Okay.
great.
He is the best.
Annie, you're a good reference. That's like,
Oh,
I feel like, so.
Let's get him in here so we can see, we can test it.
He is the best. I will say that we have a lot of resources of people who are really smart and do this work and can look at market factors with us, and I'm really
That's great.
confident we're gonna be able to do that. Deputy sheriffs, we have state transport as a comparison to some extent. Civilian support staff, we have the same thing. We have lots of civilian support in state police and all other municipals. So I think that's not gonna be as hard as it could be. I think Roger addressed the 5%. Right now I think everybody's working through. There's a lot of conversation about that. I think what we came up with for that period of time, saying this is what we're going to do until you come up with something different. Probably.
sorry, Annie, I've lost you.
Oh, I'm sorry. I was on,
Are you still in the recommendations for
yeah,
compensation?
yes, I'm on page 10 where it said Vermont Sheriff's.
Wait,
Oh, I'm sorry.
I was back.
I'm sorry. I was on compensation. Yes, I'm sorry.
Okay, so you're now under 5% contract. Okay,
Yes,
sorry.
yes. And I did already talk about Group G, so I won't bore you with that. But the 5% contract administration fee, I think we talked a little bit about that at the beginning of this. And recommendations on the use of the 5%, we think obviously at some point, caps and restrictions, vis-a-vis a fair comparable salary and benefit. I don't think we need to say a lot more right now, but, because I think what's the stopgap that you put in through the S17 and Act 30 is gonna work for at least for, and then it can be reevaluated at some point down the road.
Okay.
And then,
Would somebody just kind of remind me when the 5% fee was put in?
I don't know.
It was in the 90s, yes?
Oh, where I got.
Kevin McLaughlin told me that it was in the, I would say, actually, he's with the state's, Tim Ash, Gabe's service.
Yeah, I thought it was the early 1990s. It's like 1991 is what's sticking in my head.
That could be,
Yeah. And there was a conversation then about sheriff compensation and about how sheriffs were not compensated sufficiently. So the legislature came up with this scheme that allowed you to get more money, but doing it
Sure.
through
There is one other piece to that.
contracts.
I think if I'm not mistaken, at the same time, it was decided that all civil service of paperwork, the state would get 15%, which amounts to.
which we turn in every year.
15% of the 5%?
No, 15% of all the civil service.
Oh, civil
The
service.
sheriffs used to, that's how they used to get paid, is by service of paperwork.
It's your civil process.
So then the victim is, or the person you're serving pays that fee,
no, first requesting a service.
or the court?
Sometimes private attorneys, representing a plaintiff, so they serve, so,
Yeah.
yeah, so they pay the fee. And then the sheriffs have to keep a log of how much they've collected. And then every year they have to get a check to our department, and we send it into the treasurer,
We do it every quarter.
or every quarter. Yeah.
Mhm. This is for the personal service.
Yeah,
Yeah.
so in lieu of that money that now went to the state allowed sheriffs and Senator Norris, if I'm wrong on this, but my understanding is that they allowed them to augment their salary in a bit way.
It was sort of some probably compromise scheme in the early 1990s.
It had to have been a compromise.
Um,
And I know that I've probably said this to you before, but I just also want to say that one of the things that's important on that 5% is that there are things that the sheriff's department provides that, for example, the state benefits from that they don't pay for. So the transport deputies who are moving people all around, our 24 transport deputies, sheriffs buy their cars. And, we're not paying that. The state of Vermont isn't paying for that. And the uniforms and their guns and all that stuff. So there's a lot of stuff that goes into providing that the sheriffs are able to use some of that 5% to buy and to pay for that. Otherwise, the sheriff could say, sure, we'll move people from the correctional facility to court for their hearing, but you're buying the car and you're gonna outfit that person. We don't do that now. So I do want to say that there's very proper uses that the state would otherwise have to be on the hook for.
Right.
Question of managing it.
Yeah.
About the sheriffs. So this is, we're still working through what, in essence, we've got this intersect between Act 56. So if there's a complaint about the sheriff, is it just rise to the level of an Act 56 complaint? If it's about a sheriff's staff member, it really depends on what the complaint is. If it's a complaint that the sheriff's staff member was driving too fast, uninterested or something, it's gonna go to the sheriff to be reviewed. It may or may not rise to anything under Act 56. The nice thing about Act 56 is it's like a second check on everybody's
Serious.
serious issues.
That's the establishment of the Criminal Justice Council and the sort of,
What year did we do that?
4
years
ago.
ago? Yeah, it was, I think it was 2019, maybe?
Yeah.
It was I think my first session here. That's the,
So it's a decertification bill or something.
No, I remember doing it, I just can't remember the year we.
and the next bill we're gonna look at is sort of updating that a little bit, so.
So in some ways, the sheriffs have to look at their own folks, their own deputies. And then decide, you know, if they're going to deal with it, because it's not a serious issue, or if it is, then they have to comply with Act 56. If it's a state transport deputy, then they're covered by the VSEA contract, it comes to our department. We have to do the same thing. We would have to still also look at whether or not there's any Act 56 violations, as they are sworn law enforcement officers. We wouldn't necessarily do that, but I will say that, you know, look, sometimes the complaint can be very small. And the sheriff might call me and I'll say, you need a letter of supervisory feedback to that person. You know, and there was one recently where somebody was very, very rude to, like, their coworkers. Wasn't anything, you know, it was just rude behavior. It wasn't racist, or they didn't say anything terrible, but they were just being obnoxious. Just ugly behavior, and so they got a letter of supervisory feedback. We also had one where up in Caledonia, where it was basically, he was being prosecuted, you know, it wound up that he got prosecuted, and that needed to go to Act 56. I always say to them, if it's anything like that, I'm going to present it down to the council and stay out of it, because the scope of that review is very different, and it's really, they're looking at very different things. They did, so I just think that we have to also be aware of Act 56. And sometimes I actually called Roger one day and just said, what do you think about this? You know, so we do consult, but I also have my own relationship with people down at the council. So I can pick up the phone and call them at any time.
But one of the things that we have to do, and we've not done well yet, hopefully with a director, is we have to have a credible internal investigations capacity. And it's my feeling that that should be a central standardized, so all of those investigations are done the same. And that's one thing I think we have.
Yeah, I think that would help too, a depersonalizes it more.
Yeah.
Yes. So how are you advertising that position? Have you done a broader outside of Vermont?
That's, so what we do with the post, which is we're originally just doing in kind of internal conversation, but what we're going to do is when we post to the Department of Human Resources, we post to the Department of Labor, and that gets scooped, Indeed and Monster, I think, grab those at night. And then we'll send it out through the law enforcement networks and and probably post it. We have like 50 employers that we use for law schools and other places, victim advocates, have their own networks. We'll put it out to what we call our traditional network.
Okay. Good. All right, carry on.
And then the advisory commission, which we've been asked under the law to put together a sheriff advisory committee. And that would be with law enforcement, stakeholders, community partners. And we would like to make sure that we get groups that represent the statewide advocacy organizations, victims, persons with disabilities, historically marginalized communities, racial, ethnic, other disadvantaged communities, LGBTQ, and any other stakeholders. So what we want to try to do is work on putting that group together, but obviously we hope that there's a proper mission statement, like, well, what will their role be? You don't want to ask people to sit on something and not have any role for them. That's just not fair, and it really discourages people immediately. So what would we want them to do? You know, there may be pieces of the compensation policy, there may be pieces of the general policies that we would like them to take a look at. And then obviously the complaint procedure is important, generally speaking. But there's also pieces of the education and training. And I think about this, you know, I mean, from the perspective of, you know, when a law enforcement officer interacts with somebody who has a disability such as like a severe autism, and they are not following commands.
Yeah.
You know, and they don't understand, like, you know, so that's a really difficult thing for both the person and the law enforcement. So how do you train people to recognize that? How do you train people to recognize the difference between somebody who's acting out because of a substance that they're dealing with in their body? Like, so there's lots of those kinds of trainings, and I think some of these groups could basically help to present those trainings. And that's what I think, you know, and we also want to hear if people feel that, you know, I think the State Police Advisory Commission has heard a lot about this. Does every group in Vermont feel that they're being treated by law enforcement? This is another arm of law enforcement. We want them to tell us if they think that there's things that are happening that are good, that are not good, that can improve it. Those are the questions you always ask. What's working, what's not working, what do we do better?
Yeah.
It's also going to be an opportunity for us to learn and then maybe have another recruiting, be able to recruit some people from disenfranchised,
Yeah,
so.
diversify the
it's-
force.
It's an opportunity there.
Yeah.
Yeah.
The next, I just want to call on the bottom of page 13. The next section, creation of a sustainable funding model for sheriff's departments. You say the Constitution called for a sheriff's department in each county. It actually does not. And Tim, you're here to correct me if I'm wrong. I think the Constitution actually calls for that the legislature creates the district boundaries of so
I think that's
the
correct.
there could be one sheriff, essentially. It could be a statewide position, or there could be 30 sheriffs, if or whatever. I think it's, and Tim, if I'm wrong, please correct me right now.
I think that's correct.
Yeah, I remember that specifically in the
Okay.
many, so just.
Okay.
There.
All right, and then I think we've pretty much been through everything for you.
Okay.
All right.
Well, this is really helpful, and I'm sure this is posted on our website too, yeah. And we are going to be looking at sort of law enforcement oversight issues in the second half of the session. H 872 and then the bill that we just got today. I don't think it's even on our wall yet. We'll be using them as sort of vehicles. So if there are things that have come out of this report that require legislative action now, you did mention one of them, but that would be helpful to know for sure. And also I just, the committee, please spend a little time on this report and see if there are other things that come to mind. We can certainly have Annie Roger back for more questions. Send her away.
Thank you, Madam Chair. I did just want to note, we have H 585 on our wall. And I would love for us to take that bill up and to talk about it more seriously. That's the.
Yeah. We may be taking that up, we may not be. But we will talk about it.
Okay.
Thank you.
So one
Go ahead, yeah.
So one thing I think that would be helpful would be a conversation, and it's probably not for this year, but maybe for next year. Would be the whole concept, and I know the council itself is doing a lot of work on trying to figure out what they're, how to revise and what will they look at. We've actually had the conversation, will they still have a level 2 or level 3? What are they doing? But one of the things that would be really helpful would be to figure out ways to get more people into these jobs, into all aspects of, I don't have back on labor, but creating opportunities for people to get into jobs, almost in the manner of a training position, so that you basically prove competencies and you can move up. The state used to do that for many, many years. For people who've been around a long time, I can remember there was a program called VCOP, Vermont Career Opportunities Program. It was run through a branch of the Department of Personnel, and they basically were working in probably similar to what you might see with retail, but there's a little more specific, where they went out to state agencies and they actually got you to commit to taking 1 or 2 people into your own department for certain jobs. And I can tell you that there were people who started in state government who came in through that door, because you don't have to meet the minimum qualifications to get into these positions. So they came through, and some of these, there were 2 people who were commissioners over in the state government came in through that door many years ago. But in addition, they used to be able to take almost any position in state government, and whatever the pay grade was, let's say it was pay grade 18, you could come in 2 pay grades below. That's what they call, so I'm making up, social worker trainee, 2 pay grades below. Of course, that's a license now, but years ago, it wasn't. And what they would do is basically say, you have in essence like 18 months to show that you can move towards full competency. And they could extend it a little bit if they wanted to get you there. Once you hit that, then you basically have it, moved into a job. So we're having a hard time filling every type of position in state government. And we need to go back to some of the basics that we used to do to get people who maybe don't have those basic, either the education or the minimum qualifications to get them in the door and let them learn on the job. I mean, apprenticeship is sort of the model of that, and you don't even have to necessarily be going in that model. But we have to get back to getting more people into our jobs in Vermont.
Larson, you have the last word as the economic development.
Yes,
We're gonna
I was
bring it
gonna
up.
say, we have several CT and career technical education centers that have policing and entree into policing programs. And I think we just need to start getting our sheriffs and police officers and all of our public safety crowd into schools and talking about how wonderful the real pleasures. I mean, we have a lot of rebuilding trust in these areas as well, and I think this is a great time to be doing it as we and boy, we need those young people, but they're there, they just need to see a great role model, and and maybe summer jobs, maybe summer internships. I mean, there are a lot of creative things we could be doing to get kids engaged in this work.
All right, well, we will definitely have you back, as we continue the conversation, but thanks, this has been a really helpful
This is
reminder and
terrific.
update
Thank
on what the work we did last session. Thank you both.
It's also
Take
nice
care.
to see the results of our work. Or your sessions.
We're gonna move to H872, and this is. Thank you. both.
Thank you,
Take care.
Senator.
Bye, good to see
Thank you,
you.
Olivia.
Could you? Is there, is there a motion
yeah,
or
There's
a?
wine, free muffins, there's chocolate.
Oh my god.
And I have white chocolate.
I'll have-
I have white chocolate too.
I brought in chocolate and it's
Thank you.
unadulterated chocolate.
I love it.
Well, that's not me, I brought in enough chocolate.
Oh, okay. This
I
is,
mean, I'll, just so we can test it out. I mean,
go ahead,
for
try it,
quality
make sure it's okay.
assurance, for-
Oh, I think you have.
You really have. You gotta make sure it's
Yeah.
standard.
I also have, I got a
Okay.
white chocolate.
Let's not get too far off track here. Now that I have chocolate, everybody get chocolate.
Everybody else has dark chocolate.
We are moving on to H872, related to miscellaneous updates to the powers of the Vermont Justice County and duties of law enforcement officers. And we have Tim with us, who's gonna walk us through this. Rep McCarthy's on the floor, so we're gonna wait and hear from him after, but. And then we have the witnesses up on the screen with us from the Criminal Justice Council. So, Tim, hi, how are you?
Sure, Hardy. Doing well, thank you.
Good, it's nice to have you.
Are you okay?
Been better, but
Oh, do you have did you get a sinus infection?
nobody quite that.
Okay, but go to the doctor.
Because she's now on antibiotics and is feeling much better.
You think you're gonna get better, you're not gonna get better.
He might get better.
You may
All
get
right.
better.
All right, I'm gonna talk about Tim's health on Zoom here anyway.
So sorry.
So Tim, thank you for being with us. We're sorry you're not feeling well.
Thank you very much for having me, Sharon.
If you can walk us through 872,
Yes,
that'd
I'd
be
be happy
lovely.
to. For the record, my name is Tim Devlin, Legislative Counsel. Before you, committee members, you have,
Allison has the medical lab.
let's see,
The
H
bill.
eight
Oh, I'm
seven.
Sorry,
They were all for me.
You get them all bills.
sorry, Tim. Go ahead.
So H72 is 872 is an act relating to miscellaneous updates to the powers of the Vermont Criminal Justice Council and the duties of law enforcement officers. For a little bit of context, this came about from, let's see, recommendations brought to the House Gov Ops Committee, initially as part of a report drafted by the Vermont Criminal Justice Council. Let's see, this is January 3rd, 2024 of this year. They were charged under Act 56, a review subcommittee to examine disciplinary measures And, I believe the committee, just now has access to this, but, as part of that report, there was an appendix B with some suggested statutory language. Some of that has, been translated into, this bill, but for, some reasons having to do with, what can and cannot be delegated, this bill appears a little bit longer than appendix B does in the initial report, so that this year. In essence, what this bill does is substitutes what's category B conduct for when those individuals carrying a certification for law enforcement officers are subject to discipline. Category B conduct will be replaced in whole by a to be created law enforcement officers code of conduct. And so which will be adopted by rule and based on some statutory structuring throughout here that largely emulates what was in statute before under category B conduct. So it'll look pretty similar if you go back and look at the other one. In addition, it examines and retools when the Vermont Criminal Justice Council can take action on an offense, first offense. Before it was essentially category A, some category B, really kind of, if it was resulted in, it was physical in nature.
Right.
And then non-physical category B and category C, this conduct can only be acted upon or sanctioned in an instance of the second time it occurred or
Right.
after that. And so what we have now is reflective of a, what was framed as a compromise between the Vermont Criminal Justice Council and law enforcement representatives they were meeting with, and in essence, it limits the council can take action on a first offensive category B conduct, however, only to the extent that the agency itself has already sanctioned the officer, with some exceptions to that. So if the local agency has sanctioned, let's say, a suspension of 1 month, the council couldn't go into 2 months. It would have to correlate the suspension of certification to that 1 month. That's bad example, it's already a statute. That's kind of the gist of it. And then there's some exceptions to that. They'll get into 5 categories exception. Permitting when the Vermont Criminal Justice Council can go ahead and impose additional sanctions, regardless of what the agency is, the local agency has done. So, Chair Hardy, if it's the same with you, I think it's probably best just to walk through the bill as it's laid out here, and I can kind of.
Yeah, go ahead.
Okay. So Section 1 of the bill will grant rulemaking powers to the Criminal Justice Council so that it can adopt the law enforcement officers code of conduct by rule. So we have additional subsection or subdivision 11 inserted in 20 VSA 2355, where we find council's functional abilities. Skipping down to page 2.
I'm gonna stop you for just 1 second. Are you on a time schedule? Okay, are you on a time schedule, Tim?
Probably less so.
Okay, so I'm gonna swap you out first. Sorry about that, Tim. We'll pick up on section 2. Representative McCarthy, thank you for joining us. So we're looking at H 872. So if you want to just give us the overview, that'd be great.
Yeah, so this H 872, sorry, Representative Mike McCarthy. I am the Chair of House Government Operations and Military Affairs, represent St. Albans City. H 872 is really a follow-up and the result of a report that came out of our work on law enforcement powers last year. I'm sure that Mr. Detla has already explained that to you. And the important thing about this bill is that it resolves the kind of outstanding requests that we had from the Criminal Justice Council to look at when should they be able to act on complaints about professional misconduct on a first complaint. And we had left that unanswered in the work that both of our committees had done on some of these questions last year. And essentially it represents a compromise to get at that question. And the trade-off that's contemplated in this bill is really about the ability to act on the first offense, but then the sanction being somewhat limited.
You need to go.
And I'm going to have to go. So the sanction being limited by only what to the degree of the sanction would only be allowed to the point that it was taken by the agency that the law enforcement officer works for if they're still employed there. Those sanctions are not limited if it's the agency head or if it's someone who's permanently been terminated and a couple of other factors. So there are limits on what the council can do in response to a misconduct complaint. But they're able to act on those misconduct complaints on a first complaint.
Oh, so if, for example, a local police department, a municipal police department, there's a violation and they impose a sanction of, a 1 month suspension. The criminal justice council can only, that's the limit of what they can impose.
Unless they find that is unreasonable. And so there's a long, there's a lot of pieces in here about how to contemplate that, but I think that my ask to you to really give some scrutiny that we were not able to, given the timeline that we had around this bill, is to really look at what do we mean by reasonable? What do you mean by reasonable and unreasonable? But I think the framework is a good one. The idea that we should have a criminal justice council be able to act on a first offense. And I think you're going to hear, especially from folks that were involved in the writing of the report, about the appropriateness and the limits on the sanctions versus the extent to which there are exceptions to those limitations about reasonability. Law enforcement agency heads obviously may not sanction themselves. So that's exempt. So there are some pretty good exceptions to that limitation on those sanctions, but that's really the crux of the bill is that compromise.
Wow, good work, but okay.
Okay. I'm skeptical, but I'm
open-minded.
I am so I probably have like another 60 seconds or something before I should really.
That's your middle of the pack.
Sorry, this is really a tough day on the floor.
I just had a question. So this tasks the Criminal Justice Council to develop this thing, this code of conduct. Did they testify to their capacity to do so? Because I know they've testified in other spaces where we've asked them to do model policy, but they don't have the ability. They need staff.
Yeah, so the way I would think about it though is that we're not asking them to develop an entirely new thing out of whole cloth. Really, we're taking the existing category B and saying in statute, this is what it is. And then as needed, they will have the power to adopt additional things. We've essentially created the starting point here. We all have for that. So it's not as if they need to create some bad whole cloth, but you should definitely talk to them.
They're waiting to chat with us right after this, so yeah, we'll hear. Okay, thanks, Mike. I know you have to run to vote.
Thank you.
so-
Sorry to
Share.
have to testify and dash on you.
Yeah, exactly.
Take care. All right, section 2.
So, Section 2 will add a new section in Title 20. To be titled 20 VSA, Section 2371, be titled, statewide policy, law enforcement officers code of conduct. And so A and B, A is some kind of framing and preamble kind of language, followed by B, application, and then we get to see the contents of the bill. That is the framework of the contents of the code. That is the framework of what the code must entail. So A reads creation and modification of the code. The council shall create, implement, and modify by rule a statewide policy known as the Law Enforcement Officers Code of Conduct, or code. This code effectuates the principles that law enforcement officers serve the communities of Vermont and protect all persons against illegal acts in a manner consistent with a high degree of responsibility and respect for human dignity required by the profession. Next, B, application. Each law enforcement officer, as a condition for obtaining and maintaining certification, shall comply with the provisions of the law enforcement officer's code of conduct. And one thing here to note, unlike many of the other policies that are found in Title 20 relating to law enforcement, this is particularized to the individual versus the agency.
Okay.
C, code of contents, and this is where much of the struck language in that was under conduct category D conduct is kind of reworked here. And I'll point out some things that are in addition or maybe called out there were implied before we're now appear explicit here.
It's the appendage that you're talking about.
Oh, sorry, no, I'm just not sure. I'm sorry.
Or no, so this part that you're striking out, you're saying it's now all in the law enforcement, that code. Got it.
We haven't struck out.
There's nothing struck out.
Oh, I'm sorry, are you not on
We're
section
on
4?
page 2.
Oops. Sorry, I was kidding.
Sorry.
Let's go back to the comment.
Sure, go ahead.
So, I'm sorry, you whizzed by this applies to the person and not the agency, and I guess I'm not clear. This whole code of conduct, I assume applies to the person.
Yes.
You made
law
some
enforcement
comment
officer.
about the agency
Sorry, so other,
versus the person. What applies to what?
sorry, yeah, so the code of conduct, once implemented, will apply to the individual law enforcement agency will be responsible for policing. Whether that is being upheld or not by the individuals, and they would investigate alleged misconduct involving that. I only made that note just to because other policies, things like fair and impartial policing, are more kind of kept by the agency itself and gathering data and things like that. And therefore the agency would be in violation of the policy versus an individual.
Yeah, okay, and thanks, I just.
Yeah.
Thanks.
The code of conduct, the law enforcement officer's code of conduct shall prohibit the following categories of conduct. 1, criminal conduct, including conduct defined as category A conduct in section 2401 of this title.
That's where.
2, untruthfulness, including in the course of criminal investigations in law enforcement agencies, internal affairs investigations, counsel investigations in matters before a tribunal, and in the preparation of administration or taking of any official examination conducted by a law enforcement agency of the council. This is one of those items that was implied before, but is now made explicit. 3, misuse of official position, including A, sexual misconduct and harassment, B, misuse of property and evidence, C, solicitation, taking and giving of bribes, and D, use of electronic criminal records database for personal, political, or economic gain. 4, discrimination and bias enforcement. 5, unlawful use of force while on duty or under the authority of the state pursuant to section 2368 of this title, including failure to intervene and report to a supervisor, observation of unlawful use of force by another law enforcement officer. And D6, domestic violence. This is what the committee most recently examined in last year's criminal justice council conduct bill. Domestic violence while on or off duty, including attempting to cause or causing physical harm to a family or household member, or placing a family or household member in fear of imminent serious physical harm, or violating a domestic violence, violating the domestic violence involving law enforcement model policy
Nice.
adopted pursuant to section 2365 of this title. Then D, supplemental professional conduct policies. 1, to the extent any provision of this section or the adopted code conflicts with the provisions of any law enforcement officer's code policy, provisions of this chapter and the adopted code shall prevail. 2, a law enforcement agency may adopt additional professional conduct policies provided that these are not in conflict with the provisions of this chapter or the adopted code. In essence, this just sets the floor, and policies may be supplemented wanted by the agency. So moving on to section 3, the develop, we're now halfway through page 4. Law enforcement officers code of conduct adopted. On or before December 31st, 2024, the council shall adopt by rule law enforcement officers code of conduct. Section 4 will amend, and yes, Senator White, this is where much of it was struck out and kind of migrated to above in the earlier section. This section 4 will amend definitions, which is 20 VSA, section 2041. And here we see category B, well, reading through this struck language, reads category B conduct means a willful failure to comply with the state required policy or the law enforcement officer's code of conduct. Then breaking across page 5 there, you can see those items that are struck should look pretty familiar. They're for the most, well, entirely.
Yeah, it just get incorporated
Exactly.
in the conduct.
Yes.
Yeah, it seems like I might be different, but that's, yeah. It's numerical versus,
The Y1 do.
well, so 6, so. Whatever. Because this part, so this language is stronger than that, is basically what I'm picking up on. Like this, so, or like it's more encompassing for 6, and because 6 is I.
Right, the domestic violence involving law enforcement officers.
Yes.
Policy. Yes, it may be phrased somewhat differently, but it certainly covers the same.
Okay, and it even just, I like how this part is than the other, because it seems like this captures something where it may not be domestic violence, big D, big V, but the situation that I'm understanding is where you could be putting someone in fear for their life. So it doesn't necessarily cross into that bound, but like you might not want someone in that position. But so this feels like it's stronger language on that front, or was they doing the same thing?
Well, the 0.6 above combines both subdivisions H and I.
Oh, okay.
Yeah.
Okay.
So it just makes it more economical, in other words.
Oh, even better.
Economical
I
and.
love that.
Senator
Thank you. As a bit of a follow-up, I'm assuming, which I know can sometimes get one into trouble, that domestic violence as it is used here is as is described elsewhere in statute. Is that under criminal or civil definitions?
The domestic violence, referred to here in section 2365, I believe that I pull up that cross reference to determine whether that's referring to the policy. Yep, I don't know. I've had, but
Okay.
I've considered.
That would be,
Yes.
well, because we do sort of, and we're discussing the judiciary right now, sort of have different definitions depending if we're talking criminal law or civil law.
Yeah.
The.
Yes. Yes.
So to answer your question, domestic violence training and domestic violence involving law enforcement officers and law policy, this is 20 VSA section 2365. This requires at least 8 hours of domestic violence training in order to obtain or maintain law enforcement officer certification. And then retraining every 2 years. Let's see if there's any crop reference definitions. And then constable. So this just requires the policy be created and adopted. Presumably, policy itself would have reference to what is meant by domestic violence, but not having that policy at my fingertips, I'm not exactly sure what that definition is. I can look that in, look that up.
Yeah, and we might want to add a definition to make sure that we're clear on which definition want them to use.
Okay,
Just a pin on that.
On page 7.
On page 3, just the definition of domestic violence and Senator Yoski's question about whether that's criminal or civil. But
Depends on the violence, I guess.
we'll come back.
Well, that's,
What page we on, sorry?
that, we are back on page.
Gone back.
Okay, we are now back on, we're on page, top of page 5, I think. Oh, no, top of page 6.
yes, so bottom of page 5, breaking 6, we have section 5. 20 VSA, 2407, that's limitation on counts and sanctions, is amended as follows. So this clarifies some of the language for offenses of category B and category C conduct. Before, the statute was actually silent as to what would be done, the first offense of category C conduct, so this makes it very clear. So offenses of category A, category C conduct, after a valid investigation of either of those, conducted pursuant to section 2404 of this title, as after those investigations conclude, the council may impose a sanction for first or subsequent offense of category A or C conduct, period. Then skipping down after all the struck language, we have a new refashioned subsection B, saying the first offense for category B conduct.
Okay.
And after a valid investigation of category B conduct made pursuant to section 2404 of this title concludes, the council may impose a sanction for first offense of category B conduct only to the extent the sanction does not surpass any disciplinary action taken against the law enforcement officer by the law enforcement agency for the same alleged conduct. That's the starting place. And then unless, then we have 4 categories of exception. 1, the law enforcement officer is terminated for the same alleged conduct or resigns. 2, the alleged conduct is committed by a law enforcement agency's executive officer, which is different. 3, pursuant to section 2408 of this title, the law enforcement agency fails to conduct a valid investigation of the alleged conduct. 4, the disciplinary action taken against the law enforcement officer by the law enforcement agency is clearly unreasonable considering the following factors. And these are what determines the reasonableness here. And just to provide a little context, these factors are borrowed from Vermont Labor Relations Board case called In Re Colleran. And they're, except for one, which I'll point out, they largely emulate what was later adopted in case law of Vermont Supreme Court as it examined various labor cases. So what is considered unreasonable, following factors are A, the nature and seriousness of the offense. B, the law enforcement officer's job level, certification level, and type of employment. C, the law enforcement officer's past disciplinary record. D, the law enforcement officer's work record. E, the effect of the offense on the law enforcement officer's ability to perform satisfactorily. F, consistency of the penalty with those imposed upon similarly situated law enforcement officers. G, consistency of the penalty with any applicable agency table of penalties. H, the notoriety of the offense or its impact on the reputation of the law enforcement agency or law enforcement agencies as a whole across the state. That latter clause in H is new and that did not appear in the Labor Relations Board case. I, the clarity of notice. J, the potential for the law enforcement officer's rehabilitation. K, mitigating circumstances surrounding the offense. And L, the adequacy and effectiveness of alternative sanctions to deter such conduct in the future. So when the Vermont Criminal Justice Council is determining whether the law enforcement agency's disciplinary action was reasonable or unreasonable, they will take into account those factors.
A through L.
Yes.
It's a lot.
Senator Lewandowski has a question.
Yes, my question is about subsection big H, the notoriety of the offense. Does that have the effect that if for some reason the media picked up a certain instance that now I could be punished more or less? I'm really confused about how that
With that.
pertains to reasonableness. And I have some pretty deep concerns about how that could play out in real life if that is what it means.
Sure.
Yes. Yeah, and that's the one part that's not from the case.
Well, it was a lot of fun. Let me see if I can find it. Let's see, notice potential. From case law, it was case as the notoriety of the offense or its impact on the reputation of the agency. So what was added was
For
for
law
law
enforcement.
enforcement agencies as a whole across the state. I can look into the context of which that element was discussed.
And maybe Bill has some.
That would be really helpful.
Yeah, I can take note of that.
See it going both ways on that one.
Yes.
Yeah. Senator Watson.
Thank you. So speaking of like going both ways, I have a question about back on page 7, 4 about the unreasonableness. Is this? Do you happen to know if the testimony was geared towards punishments being unreasonably harsh or unreasonably soft? Or like, is it meant to go both ways, or is it meant to be like, well, unless it was unreasonably too harsh? Like, it seems like it would be.
That's an interesting
I
question. I think it would go both ways as written. I don't recall if anybody testified exact point or not.
That's helpful. And then on the next page, 8 with capital F on line 5 and 6. Consisting of penalty of those imposed on other similarly situated law enforcement officers. Is that intended to be within that same department, or is that across departments, like looking statewide?
Interesting question. I think we right out of the way.
Okay.
Similarly situated, I can certainly take a look at case law and see if that's been examined in isolation or what degree has been discussed by the boards.
Yeah, because it could also be rank or, cross rank or cross region or a thought that's, is it, what is the situation that they're trying to decide if it's similar? Yeah, okay.
Is it an assessment or an appraisal of the?
There you go.
Well, there's a lot of language in here that seems somewhat subjective, and if there isn't a fair amount of examination, my concern is it just sort of upholds existing systems and bias, and because we're just like.
Yeah.
Yeah, like if I'm similarly situated and all the similarly situated people come from a specific
Yes.
background, is that because are we just perpetuating sort of,
I
go
also,
ahead.
sorry, I just also want to add my voice to concern about capital H. I'm willing to have my mind changed by compelling logic, but as it is, I have a lot of, I feel like this is like a door for unreasonableness. I'm worried about that.
Yeah. Senator Norris.
Yeah. Jim, I have a concern on C, on page 8.
Okay.
1C, where it says the law enforcement officer's past disciplinary record. Is that his or her past disciplinary record through the council, or is that through in-house and those personnel records expect to be handed over to the council, or is it something they're gonna
That's an open question.
subpoena, or what they're gonna do with it?
Okay. Good question. All right, so we have a bunch of questions on this list. But this is our job, and this is exactly what Rep. McCarthy suggested, the list of what is unreasonable, that we heavily scrutinize it, which I would expect nothing less from this group. Senator Clarkson.
To tag onto your question, how would an officer be hired by a department if there had been past disciplinary records with the council? I mean, I would assume that any agency hiring an officer would have learned or was cognizant of what the council was cognizant of.
Well, just because the council has handed down disciplinary action, doesn't mean they're not eligible to be hired. And now there's a new law that states that
All right.
other agencies must release the information on those officers. They exclude them from being hired from another agency, depending on the level of their offense.
Right, but we
In
don't,
fact, we did that last year.
Right.
That was.
but we don't want revolving doors, but I guess my question is, so as a result, though, wouldn't any hiring agency be aware of what? I mean, nobody would be hiring somebody unaware.
But this is not about hiring, this is about,
Discipline.
discipline.
No,
And so it's, I think Senator Norris's question is, if it's a local agency, will they have to turn over records to the Criminal Justice
Yes.
Council? And if so,
I,
how does that work? And is that something?
I don't know if it's clear.
oh, okay, because that's what we were hoping, I think.
Yeah, I think that there's it could go either way. Yeah.
Well, I think they're two different situations, discipline versus hiring is two
Yes,
different.
yeah, and I'm sorry, I was
situations.
complaining, I'm sorry,
Yeah.
that was my.
Tim, carry on, so we can get to our witnesses.
And let's see.
They're so restrained.
So at the bottom of page 8,
Yep.
move on to second or subsequent offense of category B conduct. And this allows the council under investigation category B conduct to impose a sanction for second or subsequent offense. And then offense is defined, that's not changing in the statute, just the lettering is. Moving on to the effective dates, this act shall take effect upon passage, except that section 2 and section 4 and section 5 shall take effect on January 1st, 2025. And this will allow the council to adopt the code by rule before things switch over. That is category B conduct changes over to the code of conduct.
Okay, Sarah Watson.
Okay, I apologize for the elementary nature of this question, but I need like a quick refresher on the category A, B, and C.
Sure.
Which is more or egregious, or just the differences.
Happy to speak to that. So category A is generally felonies and misdemeanors. Category B is violations of policies. And then other lesser offenses. Category C has to do with interfering with investigations, either by the agency or by the council themselves.
Okay, thank you.
Okay, so that's
All right.
it's an interestingly written bill, I'll just say, it's kind of circular, it's very, the construction of it is very interesting.
And I just want to note, the report that this is based on is on our website. If you've posted today, and it includes the people who were on it, and it is a report that we asked for last year. So, all right, any other questions for Tim? Okay, thank you, Tim. And if you need to leave, go for it. Although we always love it when you hang out with us. If you want to say that's too.
I know you do not hesitate to jack.
Yeah, he was like, see ya.
All right, we are going to turn our attention to the witnesses we have on the screen. We have the folks from Criminal Justice Council. Chair Sorrell, did you wanna lead off? Or how did you wanna handle it? Bill, are you there?
Oh, maybe we can take our 15-minute break.
Bill, are you there?
Christopher's.
I see Christopher and Kim. All right. We're gonna start.
Yeah, I guess that
Did
makes
one of you want to,
Okay.
here we go.
Can you hear me now?
Yeah, we can hear you now.
And can you see me now or no?
We
Yeah.
can't see you, but we can hear you.
Okay, well, yes, I would like to start off, but just a second. Now you
There
might
you are.
be able to see me.
Oh, you're in a very dark space.
Very
Uh,
Space. You have like a dark room?
Oh, now he's coming to.
There you go.
There you go. Your camera is set.
Just excellent.
Oh, there we go. Okay.
Yeah, there you are.
I don't know.
Okay.
I don't know if this is better or not to be able to see me, but thank you for inviting me to be here today. And I'm joined by Kim McManus, our general counsel, position that you authorized for us, I think, 2 years ago. We very much appreciate. And our deputy executive director, Chris Backel, formerly police chief of Brandon. And I think it's fair to say that Kim and Chris are much more conversant on the intricacies of the proposed bill and the legal framework that the council endeavors to deal with in professional misconduct cases. And so I will gladly defer to them if I can't answer your questions. But I think Ledge Council mentioned that you in 476 last year, we had come to you and said our hands are tied largely in the category B arena, which are policy violations, in that other than in certain specified situations like domestic violence, excessive force, failure to intervene when another officer is using excessive force, that our hands were tied and we could take no disciplinary action against a law enforcement officer's certification for a first category B offense. And the council very much, given what we've seen coming through, were and are desirous of having more authority in the category B arena, and particularly with the first offense category B for the non-specified offenses like the excessive violence, excessive use of force, etc., that we are allowed to take action. And what happens now is the first category B offense is essentially a private matter. We may not take any action on those other than limited situations. And when the facts warrant, we want authority to take action. And secondarily, you asked us to take a look at what other, in addition to the category B issues, is whether our authority for off-duty conduct by officers to take disciplinary action should be expanded. And the report we filed with you as of the first of the year strongly encourages you to give us more flexibility and authority in this area. And what we did once 476 was enacted was we put together a study group to get into the weeds on these issues. If you take a look at the report, you'll see the makeup of the group, but it was both law enforcement and non-law enforcement victims groups. The AG's office played a very real role. And all of the meetings of the study group were public, and ultimately the recommendations of the study group came to the full council in December, and they were approved. And consequently, when Chair McCarthy was in touch with me in late December and said, what's up with the council? Is there anything we can do to help? I said, yes, absolutely. And this bill resulted. And I really appreciate what the House did. They were under real time constraints. I don't think they got to dot all their I's and cross all their T's. And the chair said to us that, tweaking some matters over on the Senate side is not going to get anybody's noses out of joint on the House side. And so the fact that you're willing to give us some time to look into this, we appreciate it, and we hope very much that we'll have expanded authority. Third thing you did in asking the report of us was to make any other recommended changes in addition to the category B and the off-duty issues. And consequently, we hired a national organization on law enforcement standards and training to assist us. Took sampled around the country and found that Vermont is one of the very few states that doesn't have a statewide conduct policy, and that we rely on individual departments for their policies other than where we have statewide policies. For example, fair and impartial policing, which the council will be taking up tomorrow. Stay tuned on that. Use of force policy. You're no doubt aware of the action we took on Sheriff Chrismore's certification status. That was for a violation of the state use of force policy. So we suggest that you direct us, order us to adopt a statewide code of conduct, which will be applicable to all state and local law enforcement. And it doesn't mean that an individual department may not have its own code of conduct, but this draft makes clear that in the event of a conflict between the local department or agency's code of conduct and the statewide code of conduct, that the statewide code of conduct trumps, if you will, a bad word, overrides the local department's policy. We are given more authority to take action on a first category B offense. Our hands are tied a little bit on a first offense B by what is done at the local level. But as Ledge Council went through, we are in a position to override if it's a situation where the officer is terminated or the officer is allowed to resign in lieu of disciplinary action. Our hands are not tied at all. Looking at that officer's certification status and his or her conduct and what we should do on their certification status, which, going back to earlier during this hearing, questions about does the next department find out about what was done by Officer Jones before, that we would be in a position to take action even if there is a voluntary resignation on that officer certification status, which would follow right along with him or her if they went to another department looking to be employed. We do have this standard that we can override if what is done at the local level was clearly unreasonable. And that's a hoop for us to jump through. But the truth of the matter is our disciplinary actions are subject to being appealed into the courts of the state. Sheriff Chrismore has filed an appeal with the state Supreme Court. I haven't seen the brief of what they argue, but I wouldn't be surprised that part of the argument is that we were unreasonable ourselves in determining that his certification status as a law enforcement officer should be permanently revoked. So we're accustomed to meeting a reasonable standard ourselves. And if we feel that Department X is unreasonable in what it has done or not done to an officer for whatever conduct, we can take action there. We have that standard to meet. But the beauty of this is that first category B action that is taken at the local level, that if we chose to challenge that, all of a sudden there's public scrutiny to what Department X has done in the case of an officer, where maybe it felt that a letter of reprimand that would only stay in the file for 30 days and then be gone or something like that. If we thought that was unreasonable, there would be able to be some light shown on how that particular department is policing its own. So the idea with the code of conduct is to have more uniformity. All ships shall rise as baseline what's expected of law enforcement in the state. Individual departments are going to look to different personality profiles and such to hire. But we think a baseline code of appropriate conduct for Vermont law enforcement is important to be adopted. So that's kind of an overview from my level. This is a priority for the council, and we hope that action will be taken that will expand our authority. And I can turn it over now to Kim and or Chris, or just try to answer your questions and then look to them to the extent that I don't have an answer that I'm comfortable with.
Okay, well, thank you, Chair Sorrell. That's a great overview and history for us. You might have heard our conversation about some of the concerns about the definitions of unreasonableness and really wanting to tighten that up, for sure.
We welcome that, and we would like to work with you and Ledge Council in that process.
That would be great. Kim, do you have anything you want to add at this point?
Being very cognizant of the time, and with the hope that you will have us back, likely for numerous sessions to work our way through this. The only comment I'll make is that as you review our report, it's really important to look at the appendix where the subcommittee drafted a potential code of conduct. And it was important for the subcommittee to do that because as we came up with this idea, when we realized we need to, the fact that we rely on local agencies' policies for our Category B violations, for the most part, separate from the state required policies, as a subcommittee, we got very excited about this idea of creating this code of conduct. And you'll see in our draft of code of conduct that we distilled down, what is the behavior outside of Category A, which is criminal behavior, outside of Category C, which is violating council policies. What is the egregious behavior that both the public and the law enforcement just does not want to see in law enforcement? And what we came up with, I think, when you read through how we drafted that, it makes this recommendation feel more fully informed, if that makes sense. Like you sort of need to see one to understand the other. And so we look forward to all of the scrutiny, though, that you're putting into this, especially that unreasonable when we can reach in. That was something that was added at the end of our committee's work as a balancing factor, and we know it's not perfect yet. So we want to delve into that with you, with your view and with Ledge Council's view to see what makes the most sense to create that balance. But this was really an attempt to extend to our agencies that, there are going to be times where you do want to work with this officer and you don't want to do it in a way where you're worried that we will then jump in and decertify someone or create sanctions further than you are. But we also just want to be very careful that an agency is not giving a slap on the wrist for something that we as the licensing agency cannot permit that as a solution to that alleged offense.
Okay, that's helpful. Thank you, Kim. Christopher, do you want to weigh in at this point? Add anything to what Bill and Kim have said?
They have really stolen my thunder, Chair, and just so you're aware, I am cognizant. If nothing else, I would really like to thank this committee for giving us the opportunity to come back, and hopefully we're invited back to provide additional testimony, because in the initial read-through, I did hear some of the questions that your committee has, all legitimate questions, and we'd like to work with you on the answers to that. And to add just one comment to Kim's, in that that additional ability for us to take any action on a Category B1 also goes to the transparency that the council has with the public, that there is scrutiny over law enforcement complaints. And right now there is none with the public because a Category B1 is kept confidential. So any additional factors that we have to be open with the public and to be fair to law enforcement at the same time when they're accused of misconduct. We look forward to working with your committee and hopefully being called in a few times to testify.
Absolutely, absolutely. This is not the last time we'll have you in for sure on this. It was the group of people that got together to write the report and make these recommendations. Were they unanimous in their recommendations, or were there some people who were less excited about this?
No, in all respects, this is a group that had 14 meetings collectively. We included OPR and the Department of Human Resources in these conversations. The Vermont Troopers Association, Department of Public Safety, Vermont State Police, the Sheriff's Association. We all had very good and open conversation. And on December 14th or 19th, I don't recall now, but of last year, this report was submitted to the council and it was unanimously approved, understanding that we still need to fine tune some language on, you know, what we're doing moving forward on what is clearly unreasonable.
Great, okay, that's really helpful. Senator Watson?
Well, it's interesting because it's like a meta witness list.
Yes, I mean, we'll certainly have those folks in. This is just our first pass at it. But thank you all. This is really helpful, and this is not gonna come as a surprise to the committee, but Senator Vyhovsky and Senator Norris, I would love for the two of you to dive deep on this issue, the bill and the report, and have some conversations together. You heard the concerns of the committee. You both have experience being on judiciary and obviously your own professional experience, but if you two could take point on this bill, well, obviously the whole committee is going to work on it, but I just really want somebody to have a more of a deep dive on it. So if you, Bill and your team, if you have suggestions, suggested language, if you could send it, changes at this point, send it along to me and Olivia. But if not, I think that having us spend a little bit more time thinking about it and then really working with you on suggested changes would be helpful. And we'll definitely have the rest of the folks in just to, you know, confirm their position on everything. So we're not surprised at the end.
Yeah, we don't want surprises ourselves.
Yeah, exactly. You might recall we had one last year, and
yes, that was not a pleasant experience for me, let's just leave it where it was. I think that the study committee we put together, everyone who was interested in weighing in had the opportunity to do that, and they worked and essentially got to a consensus situation on these recommendations. And so I'll be shocked, you know, it won't be the first time or the last time in my life, but I don't think you will see witnesses coming in who are saying that they have not had an opportunity to weigh in and be heard on the report and recommendations that we provided to you, and we voted on with the full council in approving those recommendations unanimously.